What's next for Jermaine Bass? I'll tell you in just a second. Hi folks, Tony DeWitt again with another video on the law. Remember, I don't dispense legal advice here, and this is what we're talking about today. So we're back in the Jermaine Bass case today. If this is the first time you're watching, you can check out our playlist on this right up here. Here's the backstory. Jermaine Bass was married to Shirley Bass. He had left his kids alone at home while he chased down his wife who had gone to a family dinner. Apparently, he was livid about something that she did, nobody knows what, and he is alleged to have gone home to where his children were alone and gone upstairs and shot his daughter 3 times and his son once in order essentially to inflict damage on the spouse. He was trying to hurt his spouse. Almost no other way to hurt a spouse and let them live than to kill their children. And that's, at least with one of them, that's what he did. The trial testimony went on for 3 days. The verdict came in yesterday before I expected it to. I thought it was going to be at least 2 days, but they surprised me.
State of Florida versus Jermaine Bass, case number 22 CF 011717A, Trial Division 3, verdict form. We, the jury, find as follows as to count 1, murder in the first degree. The defendant is guilty of murder in the first degree, Jayla Bass, as charged. And during the commission of the offense, did the defendant personally carry, display, use, threaten, or attempt to use any weapon or firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge the firearm? Yes. Did the discharge cause death of the victim? Yes. 12 of the 12 of us find the killing was premeditated murder. 12 of the 12 of us find the killing was premeditated murder and felony murder. We, the jury, find as follows as to count 2, aggravated child abuse. The defendant is guilty of aggravated child abuse as charged. We, the jury, find as follows as to count 3, aggravated child abuse. Jermaine J.J. Bass. The defendant is guilty of aggravated child abuse as charged. We, the jury, find as follows as to count 4, attempted murder in the first degree. Jermaine J.J. Bass. The defendant is guilty of attempted murder in the first degree. Jermaine J.J. Bass, as charged. And during the commission of the offense, did the defendant personally carry, display, use, threaten, or attempt to use any weapon or firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge the firearm? Yes. Did the discharge cause great bodily harm to the victim? Yes. So say we all, dated this 27th day of February, 2025.
Throughout the entire trial, I was amazed at the complete flat look that Jermaine Bass had. Imagine somebody sitting up there on the stand and telling about having to deal with the fallout from what you had done and just looking like you were bored out of your mind. Then, yesterday, the verdict was read and he showed no emotion at all.
Murder in the first degree. The defendant is guilty of murder in the first degree, Jayla Bass, as charged.
After the verdict was read, he cried after he had talked with his lawyer. Likely Jermaine Bass feels like his life is over, and certainly until an appellate court says otherwise, his life as a free man is over. He will likely draw 2 consecutive life terms, and he will probably never see the outside of a prison again. The judge, Samantha Ward, will likely go for the maximum sentence, given that it could have been a double homicide or maybe even a triple homicide, given the amount of pent up rage in this guy's system. I can't imagine ever being so mad at my wife that I would want to hurt her by killing our children. But people who are in the throes of mental distress of that nature, they sometimes do really awful things. But in an odd way, it reminds me of the story of the man who came home to catch his wife in flagrante delicto, as we say in the legal world, with another man. And he pulls out his pistol and he puts it to his head, and his wife laughs and says, "What are you going to do?" And he says, "Don't laugh. You're next." It is essentially just that. When you do something like what he did, you are throwing away the rest of your life. But at this point, he waits for sentencing. After that, he is unlikely to see Samantha Ward or these prosecutors again. His participation in the appeals process is minimal, and everything his lawyer needs from him can be obtained in a prison visiting room. He won't be able to attend the oral argument. They don't let people out of prison to go watch their oral argument. While the defendant has the right to be present at every significant part of his trial, once it goes to the appellate process, he doesn't have the right to be in attendance. He will have to wait out the oral argument in his cell. I would imagine he feels somewhat suffocated right now, particularly having been a free man for 30 years. And if I sound like I'm a little sympathetic for him, to the extent that he is a human being and he'll be living in a structured, disciplined, confined system without free choice about what he eats, when he eats, what he drinks, when he drinks, where he goes, who he talks to that very small extent, I do. However, I'm glad the jury reached the correct verdict and saw through the defense counsel's deft choices of words in her closing argument. I do feel like they got the correct verdict. The only question I had during the course of the trial is why the wife didn't testify. And my suspicion is that on the advice of counsel, she chose to take the Fifth Amendment route. If she'd gotten up on the stand and said, "I take the Fifth Amendment," then in all likelihood, Jermaine would not have been convicted because the defense had thrown so much mud her way. Now, many of you probably wonder why the defense didn't call her in its case in chief. I mean, admittedly, they didn't put on a case, but if they had, that was one thing they could have done. They could have subpoenaed her and had her testify. My guess is that Jermaine told his lawyers exactly what she'd tell them on the stand, and they figured that it was too big of a risk to take that she might somehow take the Fifth Amendment. You may wonder why, if she didn't testify, what she thought would incriminate her. Well, likely because she might have told her lawyer, and I assume she had one, that she had told Jermaine not to leave the kids alone, but knew that he probably would. And she left the kids alone with firearms that she knew were in the house instead of taking them to a safe place. So it could very well be that there was some, negligent manslaughter, so to speak, that she could have been prosecuted for, although I don't think so. And perhaps she would have had to admit that that .380 pistol was actually her handgun that was used. Who knows why she didn't testify? That will remain a mystery. Now, some folks have suggested she was relying on spousal privilege. Spousal privilege is what protects private communications between spouses from being disclosed in legal settings. It's based on the idea that it preserves marital harmony by allowing one spouse to avoid testifying against the other in court, fostering a trusting and open relationship. But Florida law doesn't take that view across the board. Only the spouse called to testify can invoke the spousal privilege. Let's suppose that Jermaine, at whatever point, told Shirley that if she went to this dinner, he was going to harm the children, but she went anyway. Well, she could assert the Fifth Amendment because of that, because it might be viewed as negligent manslaughter to allow them to remain in the custody who said that somebody was going to harm them, right? But at trial, Jermaine could not have forced her to not testify through the spousal privilege. Only the spouse who's called to testify can invoke that privilege, giving them the choice of whether or not they provide testimony in a criminal case. And because it applies to communications, the privilege could only have been invoked as to what was said between the couple, not and only that was heard, that was outside the hearing of other people. It would not preclude her from testifying about what she saw or heard. But the overarching reason she could not have asserted the privilege is that in Florida, a wife can be compelled to provide testimony against her husband in cases involving domestic violence. Spousal privilege is void in cases involving crimes against spouses or children, meaning that the spouse cannot claim privilege in such instances. So, for multiple reasons, the whole spousal privilege thing didn't apply. Now, we will probably never know why she did not testify, but the state was wise not to put her on. They could explain the horror and trauma meant that she just couldn't face the ordeal. They could have handled that in oral argument. But if she came and took the fifth, it would probably have been all over, again, based on the truckload of dirt that had been dumped on her at the trial by the defense. So, what happens next? I'm glad you asked. His lawyers will file a motion for a new trial, citing all of the errors they believe the trial court made, and they'll also file a motion for judgment notwithstanding the verdict. And after all those motions are ruled upon, they'll file a notice of appeal. A notice of appeal sets in motion several things. The evidentiary exhibits that were made at trial and presented at trial, those are going to be collected and stored. Those that can be stored electronically will be. Those that are physical, like the firearm, will be preserved in an evidence locker in case the appeals court wants to see them. In most cases, they don't. The record will then be compiled. There are usually two parts to the record. The first is the legal file. That starts with the indictment, and it runs through the notice of appeal. Every document filed with the court, every document seen by the judge, filed by one of the parties, is in that legal file. It is the paper record, and in a case like this where there were multiple motions, it's probably going to be over 300 pages. Next, the court reporter will prepare a transcript. She will type every word of every encounter that was done on the record. Now, sometimes procedural motions like continuances are handled by telephone and are not transcribed. But everything else, every other session that was heard on the record, will be transcribed, including the trial itself. That record, the transcript, and the legal file are what the Court of Appeals will rely on. They won't look at the video stored on YouTube because that's not the official record. Now, transcription takes a while. The court reporter has other cases and other hearings to go on every day, and she has to take those down with her stenography equipment. Many of those will never be appealed, but she knows this is going to be appealed, so as she has time during the day, she will start working on transcribing the proceedings, including the bench conferences. The transcript is likely to not be ready before the end of summer. While the reporter will work diligently, that transcript is not her highest priority. It's just an additional duty. Now that he's convicted, Jermaine probably has no money, and his appeal will be handled by an appellate defender. The citizens of Florida will pay for his appeal transcript at a rate somewhere between $1 and $7 a page. Some courts set rates that must be paid, and you have to abide by what that rate is. If the state is paying for the transcript, my guess is there probably won't actually be a check cut. A good rule of thumb for a typical transcript is for every minute of court time, there is 1 page of transcript. So while court usually goes over an 8-hour day, given lunch breaks and other breaks throughout the course of the day, there's probably only about 6 hours of actual trial that is transcribed every day. That works out to about 360 pages of transcript every day of trial. Given the need to transcribe motion hearings, etc., it's likely the transcript will be between 1,200 and 1,500 pages. While some court reporters have voice recognition software to transcribe, and others have feed from their stenography equipment right into their computer to produce a rough draft, the job of typing the transcript can in some cases be largely automated. What can't be automated, however, is the proofreading of the transcript and the finalization of it. And that's what has to happen before the briefs can be written. And that's because while there are some cases that a court of appeals will read through every page of the transcript, this is probably not one of them. When the lawyers draft their appeals, they will do what's called a statement of facts. And the statement of facts will have citations both to the legal file and to the transcript. It will be something like transcript page 500, line 14. And the court can then go to page 500, line 14, and read the transcript, and they can find whether or not the fact is actually there. Because as difficult as it is to believe, sometimes lawyers will just fluff through a fact. They'll cite a transcript page that, while it's sort of on point, doesn't actually say what they say in their brief. I have to tell you, that's a joy as an appellate lawyer when you find something like that, because you turn that into a giant club and you beat them around the head and shoulders with it, both in your brief and at the oral argument. But at any rate, that's what goes on with the transcript. As the court reporter is generating the transcript, the lawyer's trial notes, written motions, and other filings are going to be mined for the issues in the case. Now, one of the biggest issues in the case is likely the Miranda warning issue I discussed in the other day. I'll try to leave a link to that up here. Bass, the appellant, will argue that the cops knew he was a suspect when they asked him what happened. And the state will argue, look, he was holding one of the victims. How did we not know he was one of the victims himself? And the arriving cops didn't know there was a second victim until they cleared the house. And they cleared the house, and it was pretty close in time that they asked him what happened. Did the fact he didn't tell them about the second victim initially weigh into their consideration of him as a suspect? Maybe so. But the bottom line is he hadn't been told that he was detained. He hadn't been physically restrained. There was nobody holding him by the arm or anything like that. Wasn't in cuffs at that point, and they asked him what happened. And that's when he said he was trying to take the magazine out and the gun accidentally went off. And like I said earlier, it would take something on the level of a Three Stooges skit to have a gun accidentally go off 5 times. That just did not happen. So his explanation, the state's explanation, is going to make sense because Jermaine's explanation didn't make sense. And at that time, after they got that information, that's when they put him in handcuffs and Mirandized him, because they knew now there was a second victim and that he probably wasn't blameless. They're not mind readers. Police are not mind readers. And it was a completely reasonable question to ask what happened, because the guy's sitting there holding a kid who's bleeding from his head and screaming, ow. I would imagine that this would be the primary attack by the defense, and a large number of pages of the brief, a lot of ink, is going to be spilled on that subject. They'll push hard for a reversal on that basis, and that could happen if the court finds, based on the totality of the circumstances at the time they ask him, was he free to leave? If he was free to leave, as he obviously was because he wasn't restrained, then there's no violation, I don't think. But again, courts can sometimes look at things differently than other people do. So we'll leave that to the determination of the court, and I frankly don't envy them because it really is a close call. Detention is what in most cases triggers Miranda, and it was given relatively early, but after the incriminating statement was made. Keep in mind that judges are human, and there might not be a lot of sympathy for a guy who murdered one of his children and seriously wounded the other. The other avenue of attack will be that there was insufficient evidence of premeditation, which I also think is not a winner. 1 shot, sure, that could be heat of the moment. 5 shots? Not a chance. It appears that it takes about 2 years for an appeal to work its way through Florida's appeals courts. Like most states, it has an intermediate level of appeal, a first or second district court of appeals, and then a final level at the Supreme Court if it goes that far. And you have to add another year if it goes on up to the Supreme Court. So that's what Jermaine's future looks like. If you have any questions about this, let me know. Hope you found this interesting. And that's all I have for you today. Come on back tomorrow. Well, actually, come back Monday and join me down here at the beach. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.